This isn't a repeat of the hundreds of other stories I have done in the past, but the results are all the same nonetheless. The ATF has lost another court case. Let's go ahead and talk about it. Hey Wolverines, it's John Crump, and this is John Crump News. I have a special offer for you. You can get 1 month free of my locals by using code Wolverines. Exclusive content is coming next week. Plus, the first 5 paid members will get a free signed book by me. Just go to johncrump.locals.com and help fight back against those who want to take away all your rights, especially your right to keep and bear arms, because they really hate that one. Now let's jump into the latest ATF defeat. The Firearms Regulatory Accountability Coalition and Franklin Armory won a significant victory over the ATF in a North Dakota, United States District Court, and it was really significant. The fight was over the ATF's classification of the Franklin Armory Reformation and Antithesis. The Reformation has a barrel that has straight lands and grooves. Since the definition of a rifle says it must have a rifle barrel, hence the name rifle, the Reformation does not meet this definition whatsoever. The barrel isn't smoothbore either, and we're going to see what the ATF said about that in a second, but stay tuned. The GCA statutory definition of a shotgun states that a barrel must be smoothbore. The statutory definition of a shotgun under the NFA says that the shotgun must use shotgun shells. And the ATF said something about that too, which is kind of funny. The Reformation is chambered in .300 blackout, which isn't a shotgun shell, and no shotgun on the planet uses .300 blackout. Franklin Armory called their barrel design NRS. NRS stands for not a rifle or shotgun. The Antithesis is a firearm that can use both shot shells and cartridges. According to federal statute, a rifle can shoot only a single type of projectile. Since the Antithesis shoots both shot shells and cartridges, Franklin Armory claimed that the firearm was not a rifle. Both firearms were submitted to the ATF for classification letters. They played by all the rules, but the ATF doesn't like rules, unless it's their rules. The ATF ruled that the Reformation was a shotgun under the GCA because according to the ATF, a smooth bore doesn't require a bore to be smooth. That's what they actually said. It's not a joke. They actually said a smooth bore is not a smooth bore. Kind of like a searchable database isn't a registry, right, ATF? The ATF said it only means that the barrel doesn't have rifling, which is absolutely ridiculous. The ATF classified the Reformation as a GCA-only regulated short-barreled shotgun. This classification is similar to those of a 14-inch GCA-only shotgun, just like the Shockwave or TAC-14. In 2019, the ATF told Franklin Armory that the Reformation could be sold or transferred to those with an FFL, and the owner could not take the firearm across state lines. The ATF said that it was currently developing a process and forms to address this gap in the federal firearms regulations. That was a quote. There were no ATF forms for GCA-only short-barreled shotguns. I wonder how that turned out. In 2020, the ATF failed its attempt to develop a form for a GCA-only firearm. The ATF claimed that the transport or transfer of a GCA-only short-barreled shotgun outside NFA regulations was inconsistent with public safety. We always get that word, public safety, every time they want to do something. They contended that allowances for GCA-only short-barreled shotguns contradicts Congress's intent to more closely regulate concealable shotguns through the NFA. Basically, it isn't regulated on the NFA, but the ATF said that Congress would have felt that they should have regulated it if they knew about it, so therefore they're going to regulate it, which is totally ass backwards. But hey, it's the ATF. With the Antithesis, Franklin Armory stated that they designed and advertised the firearm to fire both types of ammunition. The ATF said it didn't matter that Franklin Armory designed the gun to be fired with both shot shells and cartridges. The Bureau stated that a rifled bore is an objective design feature designed and made to only fire a single projectile. It determined that the antithesis was a short-barreled rifle under the GCA and also the NFA, and therefore you needed to pay a $200 tax stamp and a bunch of other crap. Once again, the ATF is taking liberties with its reasoning. In January 2023, FRAC and Franklin Armory teamed up to sue the ATF over the classification of the two firearms. The ATF would then change its mind on the reformation. I wonder why. Actually, I know why. I'm going to tell you in a second, so please stay tuned. It's definitely a legal tactic. The ATF issued a new classification of the reformation, and guess what? This time they said the reformation was a shotgun under both the GCA and also the NFA, even though it didn't meet the definition of a shotgun under the NFA. The ATF claimed that it was using congressional intent. There's that word again. They love that word when issuing the new classification. It said that Congress did not intend a firearm classification under these definitions to be driven by the classification of the type of ammunition the weapon is capable of firing, opposed to the objective design features and capabilities of the weapon itself. All right. Congress did intend exactly that. The ATF claimed since the shotgun shells are not defined in the NFA, it could use ordinary meaning of shotgun shells. According to the ATF, and this is funny, a shotgun shell is a cartridge for a shotgun. This definition means that a .300 blackout cartridge could be considered a shotgun shell. The ATF tried to claim that the case was now moot because the new classification letter. It's not like they were trying to moot the case or anything. They just did an action that might moot the case. Don't look behind the curtain. This argument would ultimately fail, and the plaintiffs amended their complaint. The ATF argued that the court should give deference to its interpretation of the GCA and NFA because firearms classifications requires a high level of technical expertise. Yet the top ATF firearms expert cannot reassemble a Glock. The plaintiffs rejected the ATF's reasoning. They stated that criminal statute is not entitled to deference. Both the NFA and GCA are criminal statutes with serious repercussions. This is actually settled case law. The judge highlighted in Loper Bright Enterprises the Supreme Court overruled agency deference, stating the Administrative Procedure Act directs courts to interpret the constitutional and statutory provisions, which makes clear that the agency interpretation of statutes, like agency interpretations of the constitutions, are not entitled to deference. The Supreme Court said the best reading of a statute is the reading the court would have reached if no agency were involved. The APA said that an agency action must be set aside if it is arbitrary and capricious or in excess of its statutory authority. The plaintiffs claimed that the ATF actions on the Reformation was both arbitrary, capricious, and also exceeded the ATF's authority. The judge rejected the ATF changing of the definition of smooth bore. It also dismissed the ATF attempt to define a fixed shotgun shell. The judge felt like the ATF was changing definitions to justify its ends. The plaintiffs claimed that the ATF's classification of the antithesis exceeded its authority by disregarding statutory text. The classification is arbitrary and capricious because the ATF disregarded that text as well. And the classification is arbitrary and capricious because the ATF failed to consider an important aspect of the problem. The plaintiff said that the ATF disregarded the plain statutory language of what a rifle is, and they 100% did do that, let me tell you. The ATF claimed that if the statute read how Congress wrote it, no firearms would be classified as a rifle. The judge rejected the ATF's arguments. Rifles are designed to fire a single cartridge, whereas the antithesis is designed to fire both shot shells and cartridges. The judge ruled against the ATF and said Congress gave ATF the ability to enforce law, not change it. Franklin Armory created a weapon that didn't fit into the round holes made by Congress, but did not give ATF authority to change the size and shape of the holes to make the Reformation fit. The separation of powers is admitted on all hands to be essential to the preservation of liberty. FRAC President and CEO Travis White stated, the ATF egregiously abused the firearms technology classification process, and this is a landmark ruling to rein in such abuses. Franklin Armory President Jay Jacobson said, we spent years trying to reason with the ATF leadership as they failed to classify firearms correctly. We hope the future agency leaders will stick to the law as passed by Congress. All we ever wanted was a good referee, not someone to throw the game. The judge granted FRAC and Franklin Armory their motion for summary judgment. The ATF will have 180 days to create a procedure for regulating GCA-only firearms.